So in the early years of clinical legal education, many, if not most clinics were focused on individual client representation in litigation as the primary means of serving communities and teaching social justice. And while some of us do still primarily focus on litigation, our conceptions of lawyering have expanded significantly over the last 40 years. That's a lot of what we talked about last night. And that provides lawyers with a variety of options for solving legal problems. Our goal for this panel is to explore the array of lawyering approaches that students experience in our presenters' clinics, and to think about how we can best teach our students to use a multifaceted approach to address the social justice needs of our clients and our community. To start that conversation, I am happy to introduce three of the amazing clinical faculty here at the University of Maryland Francis King Carey School of Law. So first we'll hear from Doug Colbert, who is the director of the Access to Justice Clinic. Then we'll hear from Ellen Weber, who directs the Drug Policy and Public Health Strategies Clinic. And we'll end with Deborah Eisenberg, who is the director of the Center for Dispute Resolution and teaches the Mediation Clinic. Each of them will give a brief presentation. We hope to leave lots of time for questions and discussion.
So I see you're a typical law school class. Everyone sits in the last 4 rows and one brave soul or two in the front, just as I thought you would. So I really enjoy anniversaries, and this 40th anniversary is one of the really special occasions. Phoebe's absolutely right. Last night was a total joy of really cherishing all of my colleagues who contribute so much to legal education, to community. But what I also like about anniversaries, some people say, oh, anniversaries, we're getting older, and, oh, I remember when. And what I think about is the continuity, the fact that we're here, that we're still doing, that we're growing and evolving, and that we have a community where we can really look for help from one another. So I think what I'd like to do is just take you on a very brief journey about why I came to Maryland Law School, what was happening before, and how we eventually evolved from a criminal defense clinic, very traditional, into an access to justice clinic where the students represent people who are in jail, charged with nonviolent, less serious crimes, which make up about 92% of the people arrested, but of course they don't make the headlines. In fact, you'll see right after I leave here today, I'm meeting my students over at the Central Booking Jail, and we're going to be representing such dangerous criminals as 4 people held on possession of marijuana because they don't have $150 or $100 bail. And then there's other folks charged with rogue and vagabond, a wonderful 17th century concept in common law days that should have been stricken from the record books a long time ago. But I remember back when, when teaching a clinic back in the 80s was a really big deal, a live clinic. And the big deal, I was at Hofstra Law School then, and there were only 2 or 3 clinics that we had, so that we had the choice of every student wanted a clinic because they wanted to have some practice experience. So back then, if you gave a student a live case and you said you're representing somebody and going to go to trial, it was a very popular concept. People wanted to be trial lawyers. They wanted to be the real deal. And so we started with this idea of representing people at trial, and everyone was enjoying themselves. But I really didn't get the concept of community and professional responsibility until we started representing a group of people who had been arrested in protest against the war in Central America. And they sat in on a congressman's office, and of course they wanted to get arrested. It was civil disobedience in those days. And they came to our group, and they were a terrific, actually the real Baltimore tie here. This is where Father Dan Berrigan, the Berrigan brothers, who are here at Jonah House, this was part of their group to sort of raise consciousness about the war in Central America. And they taught us a lot about community and how you can use a courtroom to really bring people into the audience. And there were lots of articles written. Following that, we represented a homeless person in Long Beach, New York, who had been arrested, not intentionally, but he had been sleeping outside on the city square because Long Beach did not have any place for homeless people. And again, we raised the justification defense, and it lit a fire in the media. They started writing about, where is community? Why aren't we doing something about this legal system that's prosecuting people because they don't have a home? So when I came down here to Maryland, I was hired by Millman. Millman does all the hiring around here. There's really no deans or anything like that. I mean, most people in this room, you know it, Michael, and I loved it. He said to me, what do you need? No, it was great. I mean, I came here because this school really, truly has a commitment. And the fact that they have a Carden program, and you weren't the oddball for teaching clinic, but rather you were part of the central piece of this school, really attracted me tremendously. And my non-clinical colleagues, I have to say, are just so supportive of all this, and it really wouldn't be happening without them. So I went from a criminal defense clinic and came in, and I went to the courthouse to see what was going on there. I remember in New York City, our biggest battle took place at that first appearance, when people were appearing before a judge, and the whole issue there was freedom or jail. And we called them freedom hearings. And we fought really hard for people, because we knew if we got them out of jail, that almost all of them were going to benefit tremendously, both in the outcome as well as in being able to prepare a defense for trial. When I came here, I saw a site that I still see as vividly today as I did 20 years ago. That's the other thing about anniversaries. This is my 20th anniversary at Maryland Law School. And what I saw were 25 people come into a courtroom in chains and shackles, leg irons, chained to each other through body irons, shuffling in because that's the only way you could walk. 25 people, 23 of them were African American. There were a couple of token white people in there. And I looked at this, and this was the scene in Maryland's first appearance. You came into court, and you appeared before a judge en masse, and I looked and I went, oh my God, is this really happening? But I said to myself, I'm a new kid on the block. I'm not going to say anything. I'm going to wait till the students get it. And sure enough, they got their first cases, and they did very well, as clinic students do. But then one of them brought this conversation to class in which the client thanked him for getting the charge dismissed, and then said, but where were you 3 weeks ago when I needed you? When I stood before this judge, I had no one to talk for me. Why don't you folks start doing something about all the people who are staying in jail waiting for their lawyer? That's when the Access to Justice Clinic began. It took a couple of years for faculty approval to get the cooperation of everybody in the system. And then we started looking at the system, and the students said, let's try and do something about it. So by then I had become familiar with the Maryland Rules of Professional Conduct. And I say that not because I wasn't aware of them, but this preamble was like, oh my God, I could have written it myself. It was just beautiful document talking about lawyers' duty to enhance the administration of justice, to focus on the deficiencies in our civil and criminal justice system. And it was the lawyer's duty to educate people, to make people, and no one knew this. I mean, I didn't know it. I was a stranger here, but my friends, we had no idea the extent of this problem. And so we began to do reform, and I didn't, you know, we talk about the litigation model, which you'll see has been very important, but the first few years we focused on the legislature. And in 1999, our first year, 15 years ago, we had everyone in this powerful coalition, including the state police and the state's attorneys, the prosecutors. We had correction officials. We had the chief judge of our highest court. We had everyone on our side, but we didn't have one. We didn't realize how political the battle was going to be and how once again it was money that ruled. And that's where we encountered the bail bond industry, and that's where we encountered all the people who are dependent, who get their money from. And it's a lucrative business. So we spent 4 years there. Just to tell you that, this is only to give you a sense of how we wound up with litigation. 4 years in the legislature. In 2002, we started working at the Rules Committee at the administrative level to try to change some of these practices. We always made some headway, but we never got what we were really looking for, which is poor people did not have a lawyer in our state for 30 days. Except in Montgomery and Hartford County. In the other 22 counties, they waited in jail for 30 or more days. And, I still am bent out of shape when I think of what's going on. And more people are now, but I have to tell you, it was not something that anyone really was too annoyed or upset about. But the students, through education, through media, op-ed articles, news articles, and of course we had the support of the State Bar Association, so we really tried our best to educate. The Rules Committee didn't work. We spent another year, the students drafted a wonderful pamphlet. We sent it around to the tens of thousands of people in jail to give them a sense of what their rights were. And finally, we decided litigation was the only thing, that nothing else was going to make a difference. We had tried the conversations, the dialogue, everyone was involved, except you should never underestimate the power of money when it comes to legislation. And so back in 2006, in November, that's what, 7.5 years ago, we filed a class action lawsuit. And I say we, the students went to the biggest law firm in the state, the Venerable Bacher and Howard law firm. Ooh, that's not a nice sign at all. But you always told me I had 1 more minute. So, and we went to that law firm and we convinced 2 of the partners that they took on the case as a pro bono case. And for the last 8 years, we have gone up and down the high court 3 times. We've gotten 2 victories, 2 big legal victories. The first one was unanimous, that everybody has a statutory right to a lawyer. The legislature turned that around in 3 months and repealed the whole statute. And then last September, we had a constitutional right to counsel. Constitutional, state constitution. And today, and just last week, some senators introduced a bill that would make a constitutional amendment to overrule the Richmond decision and put it right back to where it was. We are in the middle of this struggle right now. The reason I say all this is that we have used the clinic as a way to address the needs of community. We have reached out to a part of the community that is almost forgotten, people accused of crime. And what we're trying to do now is to continue the education, the community involvement, and allow our students to be aware and to fulfill their ethical responsibility to serve the underserved population. Thank you very much.
Thank you also for coming here today. So the mission of the Drug Policy and Public Health Strategies Clinic has always been grounded in the social justice vision to alter the way that our nation treats individuals with drug and alcohol problems. And our goal is to have our country treat these as health problems rather than criminal justice problems. And so the clinic takes a dual approach to the work in trying to achieve this mission. Its goal is to expand access to drug and alcohol treatment, as well as to challenge discrimination against individuals with drug and alcohol problems based on their disability. Now, that discrimination can be employment discrimination, it can be housing and discrimination, it can be zoning discrimination, which the clinic's been very involved in, but it also can be discrimination in the healthcare system itself. And so this is very much along the lines of what Tom Perez was referring to last night, is that health is a civil right. But for our clients, achieving those civil rights and achieving healthcare services is the way to reverse some of the discrimination and the stripping of civil rights that those individuals have faced as a result of our nation's war on drugs. And so we are very much have a goal of trying to address drug dependence as a health problem, because in our view, not only is that the humane way of doing things and not only the evidence-based way of doing things, but ultimately it's the one that leads to a more fiscally sound and practical, pragmatic approach for our country. Our goal is to try to ensure that people get the services that they need, and as those individuals regain their health and regain their productivity, slowly the stigma that surrounds drug and alcohol problems should fade away, and we then as a nation can address our problem in a much more effective fashion. So we see that all the time with our students. We take our students to a drug treatment program very early in the semester where they have an opportunity, obviously, to meet individuals who are in the process of recovery. And I think what they see is they instantly recognize the complexity of this disease, the fact that individuals, when they're given the correct services, are committed to their own health and recovery, and that many of the kinds of adverse consequences that relate to drug and alcohol problems obviously fade away once somebody regains his or her health and can regain employment and other kinds of more productive activities. So students whose only exposure often to drug problems before they come into the clinic, which is the wire, right, all of a sudden see the issue in a much different way, in a much more full-bodied and complex fashion. So I think our goal ultimately is if we can teach this next generation of attorneys to address these problems as drug and alcohol, as health problems, then they'll be able to start reversing some of the punitive measures that my generation of policymakers has put into place, and that ultimately is the goal. So how does our clinic conduct its work? So for the past 4 years, we've basically directed our attention to the huge opportunities that are now presented by the Affordable Care Act and the Mental Health Parity and Addiction Equity Act to expand access to drug treatment services. So I'm looking at Jennifer Goldberg, who has a very important role in our state with regard to the implementation of healthcare reform, and thank Jennifer for all of her leadership in this. But what we've been doing as a clinic is to try to take advantage of the new opportunities that the ACA presents. And so the Affordable Care Act now requires comprehensive drug and alcohol treatment services for all individual health plans and all small group health plans. And the Mental Health Parity and Addiction Equity Act requires that those services, really for the first time, be provided on par with medical and surgical services. And so the historical discrimination that has existed against individuals with mental health and substance use problems in health insurance is being addressed by the Parity Act. And I have to say that the state has implemented very effective policies in terms of ensuring, at least on paper, that these services are provided in a very comprehensive way. And I guess I'm very happy and proud to say that the clinic and our students since 2010 have been very involved in the state's efforts to implement those very proactive services and proactive standards and policies. So beginning in 2010, or 2011, our clinic students were involved in the development and the evaluation of all the legislation that the state was implementing to enforce the ACA in Maryland. They analyzed the legislation. They developed amendments that would more effectively address the needs of persons with drug and alcohol and mental health problems. They advocated with legislators around those issues, and they operated and worked in collaboration with our community partners to achieve what I think are some very, very effective ends. One of the interesting things I think that the clinic has also done is it's worked in a very multidisciplinary fashion, not only working with other coalition of the partners, but has also looked to the data that will help make our case. So one perfect example, and when we're trying to implement the Mental Health Parity and Addiction Equity Act more effectively in Maryland, our clinic students gathered data from the HSCRC to take a look at hospital readmission rates for persons with mental health and drug problems. And to no one's surprise, we realized that those rates of readmission were far higher, statistically significantly higher than persons with medical surgical conditions. So we took that data, we used that data to again create a more compelling case that if you implement fair and expansive drug and alcohol treatment services and mental health services and implement that coverage through insurance, then ultimately we're going to be able to reduce those hospital readmission rates, save the state some money, and create a much more healthy population. And so that's just one of the ways that the clinic ultimately goes beyond just the law, although we have a firm grounding in the law, but we go beyond the law to help make the case in the most practical way possible. So now, with the implementation of the Affordable Care Act since January 1, 2014, what the clinic student's role changes, right? So in a very classic health law practice fashion, there are multiple kinds of strategies that one must implement in order to achieve your ends and your client's goals. So where we were initially helping to develop the policy, we now have the opportunity to implement it. And while we're on the ground, to identify what's working, what's not working, and then to turn those experiences back into policy recommendations for the next set of policy proposals and improvements. And so what our students are doing right now is they've spent a lot of time learning and understanding the Affordable Care Act. And that, as everybody knows, is no mean task. But they've done a wonderful job at doing that. And we are now in the phase of going out into the community, talking with drug treatment programs, talking to clients, and trying to explain what that law is all about, and trying to identify the problems that programs and clients are facing as they implement this law. And those are the kinds of experiences that we are now gathering, and we're going to be, again, sort of turning those, analyzing those trends, and then turning those things into policy recommendations for future fixes. Along the way, we're responding to questions that clients have, and we're also able to now start connecting them because of the expanded Medicaid coverage. We're able to now start connecting those individuals to healthcare services that they've been denied for many, many, many years. And so it's really wonderful to be able to see the transformation that that law has in many people's lives. And I think similarly, the transformation that it has for our students to understand what the impact of law, the change of law, can actually have on their clients. Over the course of the next year, we're going to be assisting clients who are having adverse decisions with regard to their eligibility determinations. We're going to help represent those clients in those types of administrative hearings. So again, another component of legal practice for students. And then we are again, continuing with some other folks, the work that we had done with the implementation of the Mental Health Parity and Addiction Equity Act with regard to actually the plans that are being implemented in the state right now. So a team of our students took on the gargantuan task of analyzing all 75 plans that have been offered in the Maryland Health Connection and evaluated whether or not those plans actually comply with the Mental Health Parity and Addiction Equity Act. And what they found, they have now memorialized those in 4 very nice letters to 4 different carriers, and indicating to them where they have and where they have not complied with the law. And we're also taking the step of trying to work with the Maryland Insurance Commission so that future plans that are offered for sale in the state actually do comply with the law, and that we're able to gather information and that that information is made in a transparent enough fashion so that not only advocates but consumers can understand what their rights are and ensure that they actually get what the law requires that they have. So again, sort of a full-bodied approach to a legal practice. Our practice, I think, is quite reflective of what a traditional public interest practice is, as well as a health law practice. There's a dynamic that goes on in what we do. The students analyze, write about, interpret the law and regulations. They investigate on the ground what's happening with implementation. They identify potential compliance problems. They identify gaps in policies. They write demand letters to try to get the law enforced appropriately. They educate the community, providers, and individuals so that those folks can do their own self-advocacy, which, as we all know, is a very critical and important part of not only what we do as lawyers, but certainly what we do to assist communities. So there's a very dynamic nature to our practice, and we not only assist programs, but consumers so that they can address those problems themselves. So just in conclusion, over the past few years, I think we have begun to see as a nation sort of small changes in our policies with regard to how we treat individuals with drug and alcohol problems. We've seen with the leadership of Attorney General Holder some very important and dramatic recommendations and proposals to change our sentencing practices, to ensure that individuals who can benefit from treatment go into treatment services. And certainly with the expansion of care under the Affordable Care Act and the Parity Act, we really have a great foundation for doing that. So the Washington Post had an article just this week that was entitled, "In Drug Policy, a Turn for the Pragmatic." And I guess I'd like to think that the clinic has attempted to teach the next generation of our lawyers that pragmatic and humane policies look like what we're trying to do right now. And that if they have an opportunity to try to make a difference and to implement some of those kinds of policies, potentially our future generations will be in a far better position than we are right now. So thank you very much.
Hey, good morning, everyone. I'm going to talk about the mediation clinic, and I know a lot of my colleagues have no idea what we do in the mediation clinic. We're kind of this oddball outlier. So first, let me define mediation. I think you all know what it means, but for those who don't, mediation is a process in which a third-party neutral, the mediator, helps to facilitate conversation and negotiation between parties in conflict. And if those parties so desire, the mediator will help the parties determine what the agreement is and help write up the agreement in the party's own language. So there are 4 basic tenets of mediation. One is it's voluntary, so you can start the process of mediation, and if it's not going well for you, any party can end it at any time. Nobody is forced to stay there. Self-determination is a big part of mediation, which means that the parties in the dispute are empowered to talk about whatever they want to talk about that they think is relevant, not just what's relevant under the law, and to come to an agreement that fits their needs mutually. And that may include remedies that they can't get in court. Mediation's also neutral, right? So the mediator is not telling the parties what to do. There are some mediators who follow that model. Retired judges, for example, sometimes can't get out of the judging role, but in our clinic, neutrality is the way we practice. We do not practice an evaluative model. We're not telling the parties. We're not advising the parties as an attorney. We are neutrals. And of course, confidentiality is a part of mediation. Whatever happens in the mediation room stays in the mediation room, right? So it's not as sexy as filing a, impact lawsuit or a policy change. We don't issue press releases with mediations, but a lot of powerful things happen in the mediation room. So how do we teach it? So we teach, Toby Guerin co-teaches the clinic with me, and we teach conflict resolution theory and practice. And for any student who thinks that they can go to the mediation clinic because they want to avoid conflict, they have a rude awakening pretty quickly, because they are going into the heart of conflict where there are tears, there's foul language, you don't have just one upset, angry client, you have multiple upset, angry folks who may not be represented. And so the mediator needs to be very skilled in how to manage these conversations and help these parties figure out how they're going to come to a resolution. So we focus on active listening, right? How do you listen so that you're listening at not only the words, but what's underneath the message in the words. You look at body language. What are the feelings of each of the parties? How do you reflect those feelings so that that person feels heard and vindicated? And how do you help those parties communicate with each other by being that neutral filter, doing the reflections to one party so the other party can maybe hear for the first time that other party's perspective. So active listening, questioning, right? How to do open-ended questions, how to ask the right questions so that the parties can have a better conversation and negotiations. We talk about interests, integrative bargaining versus distributive bargaining, how to handle a distributive bargaining versus more of an integrative approach. And then if the parties do reach agreement, how do you facilitate that agreement? How do you ask all the who, what, where, when, how, reality checking questions, so that they can really come up with the agreement in their own words. And that is something that the law students need a lot of practice with, right? So that they are not dictating the terms of the agreement, that they are helping the parties come up with the terms that matter for them. So during the first semester, we focus a lot on the training, and we are at the district court, small claims court in Baltimore City 2 days a week. And we are, the students are going into courtrooms explaining what mediation is and asking if anyone would like to go to the mediation room and have a mediation, see if they can settle their dispute. If it doesn't work for them or if they don't reach agreement, they come back and have their trial that same day in front of the judge. And usually when we go, we get at least one case. Sometimes we've had 3 or 4 cases in an afternoon. And it's just some really powerful examples I'll talk about in a moment. So in addition to the day of trial mediations, the students are also every week getting pretrial referrals from the district court ADR program. So I'll have a new case for every student every week. And the student sends introductory letters to the parties explaining what mediation is, and then they do follow-up calls, seeing if they would like to have a mediation, and if they do, we hold the mediations right here at the law school. And that is, helps folks who don't want to miss work, right? So they can do the mediation at night or on the weekend. So there's a lot of flexibility for folks who want to do a pretrial mediation. And once the way the process works, because these are very difficult conversations to handle, the students observe faculty mediate 2 mediations, then they co-mediate with a faculty member 2 times, and then we have a co-mediation model where the students are co-mediating together with a faculty member in the room, and for debrief sessions, and if they need to take a break and get some help with how to handle it, that's how we do it. So what does all this have to do with social change? Coming from a social change background, I've come to realize the real power of mediation and conflict resolution for social change. This is the people's court. Most folks are unrepresented, even though evidentiary rules are relaxed. It can be very intimidating for those who've never experienced court before. And mediation, for them to come into the room and for the mediator to say, what do you want to talk about? How would this work for you? Right? They have the power, they're empowered to figure out how to resolve it without a judgment on their record, which can be very, very helpful for some consumers and tenants who have a settlement rather than a judgment on their records. They can work out payment plans. Apologies, things that they can't get in the court can be part of the resolution that the parties come to. So it not only resolves the case in a way that it can be very productive for the parties, but we've also seen just tremendous examples of how it really repairs relationships. And when I started doing this work in the Baltimore City District Court, I was amazed at how relational a lot of these cases are. There were mothers suing sons, sisters suing sisters, cousins. It was just amazing to me. And having mediation available for them has been very powerful because it gives them a model for how they can resolve conflicts in the future beyond the conflict that came to court. So just to give an example, we had a case with a mother who sued her 18-year-old son who was still living at home, who didn't have a job. And she did this as an act of tough love. She loved him. He'd never been involved in the criminal justice system. She did not want him to be a statistic. She wanted him to get his life together and be more responsible and respectful. And the son, of course, was feeling like, I'm independent, I'm 18 now, don't tell me what to do. And the students who did this mediation, it was one of the most powerful mediations I've ever observed, really helped this mother and this son to really hear each other for the first time, and to write up an agreement about how they were going to respect each other and how they were going to contribute to each other's success, and how the son was going to help with his little brother and what she was going to do to help him. And it was just, we see examples of that every time we go to court. So that is just a very powerful experience. So in addition to the court work that we do, The students are also working in conjunction with our Center for Dispute Resolution's School Conflict Resolution Education Program. So the students are taking the skills that they use in district court and then using them in public schools throughout the state. And these can be elementary students all the way through high school students. And they're doing a variety of things with these schools. It can be the law students mediating conflicts between the students that are referred by the principal. It can be the law students training the public school students in conflict resolution and training them to be peer mediators so that the students can do it. Or it can be working with the teachers, training them how to do restorative dialogue circles, where everyone in the class can have their opportunity, passing around a talking piece to talk about whatever the topic happens to be. So I have a quick video, and then I know I only have 3 minutes, and I don't think this is 3 minutes long. We've gotten some press coverage of our work in schools, and I thought the best way to really show you what's happening is to just show you this video. We can talk about it more when we have time.
The bullying problem with words, not fists, it's what one Baltimore City school is doing thanks to a partnership with the University of Maryland law students. WJZ's Live, Gigi Barnett explains it's working. Gigi?
Well, that's right, Vic. New national guidelines will soon require all schools to drop their suspension rate. One school is already doing it, but first, it starts with the right words.
There's no name calling or put downs.
The rules at this table are fair and firm, and all sides agree.
You guys are okay with that?
This is conflict resolution at Colbert Academy in Northeast Baltimore. The school has a partnership with the University of Maryland School of Law.
So who wants to start?
Future attorneys sit down with students and help them hash out the dispute and decide how to resolve it. As a result, the school is seeing a drastic drop in the number of suspensions and bullying.
There's no question about the fact that when kids resolve conflict better, they don't act out as much.
Barbara Sugarman-Groschel runs the program at more than 20 schools across the state. She says students learn how to take the problem-solving skills out of the classroom.
It's not somebody, mediators or teachers or counselors coming and telling people what to do. It's about helping kids, empowering them to talk through it and reach solutions.
A lot of our kids are good at this now.
Anthony Ruby is the school's principal. He says students volunteer for the roundtable conversations, and in the last 3 years, the school's suspension rate dropped from nearly 100 to 2.
Just punishing, just suspending, just sending home doesn't fix anything. It's more intense than just getting suspended. So this is actually a bigger consequence in a lot of ways.
And the school also points to its expulsion rate as proof that this is working. For example, over the last 3 years, they had 13 suspensions. This year, expulsions. This year, that number is down to just 1. Vic, back to you.
Okay, Gigi, thank you. The law school plans to focus on mediation sessions with 3rd and 5th grade.
Okay, so that gives you a little clip. I mean, the goal is really to get away from zero tolerance policies that are overly punitive towards kids, and give kids a forum where they can talk about what has happened and with each other come up with a solution, and get away from suspension and expulsions that will go from, sort of the school to prison pipeline. So that's the overall goal. And I know I'm probably out of time, so I'll stop there.
Unhappy with the first sign, I drew a smiley face on the one that said stop. So it was a much nicer sign then. I'm so excited that this panel kept itself to time because we've left ourselves a lot of time to have a conversation about the different kinds of lawyering strategies that we're all using, not just the folks up here, but all of us, and how we push those strategies forward. So I want to open it up for questions, and I can also take the moderator's privilege and ask one myself if people feel shy and aren't ready. All right, Mike.
This question for Helen. When we were doing law reform and legal services, the criticism was that we didn't have a client, that we were representing ourselves. How do you deal with that with respect to what you're doing? What you're doing, I think, is fabulous answers. But how do you deal with it, and do you teach it?
So I think one of the things that's most important when you're dealing with policy issues where you may or may not have a client attached. So there may be situations in which we're obviously representing a client on a policy matter in terms of representing them and representing on a certain issue. But in all situations, we're either working in coalition with individuals who will directly benefit from this policy change, and or we are directly connecting up with the folks who this policy will affect so that we get an understanding of what the guidance should be, which direction we should be moving in, get the facts on the ground so that we know how to effectively advocate and to make the case. So there is always going to be in the work that we're doing an individual who is informing us, directly involved in the advocacy, and guiding the process. So that has tended to be the way we approach it, to the extent we don't have a particular client. And in many situations, obviously, it's the individuals on the ground who have brought the problem to our attention and who we're working directly with to get it resolved through a policy approach.
Renee?
So this is for all of you. So you all talked about crafting clinics that respond to the community, and I was hoping you could talk a little bit about how or whether we're going to continue to think about being responsive to community needs going forward, to have you adapt or modify or update your clinics to ensure that what you're doing continues to be sort of cutting edge.
So one thing that we're doing, the mediation clinic was started by Roger Wolf in 1985. We were one of the first mediation clinics, and it really started as kind of an incubator in the district court when it didn't have a program. And the example of the law students mediating sort of led to now a very well-established district court program. And now we are working with the district court program to evaluate, the students are doing observations of the peace order docket. And so part of the way we do it is sort of responding to what we're hearing about, different types of cases and different types of opportunities to maybe use mediation or restorative practice circle processes or community conferencing models to respond to, other areas. So that is, and we're also thinking, what you saw in the little clip there was more of a mediation. And what we're finding is that we're sort of changing our model a little bit more to a restorative practice model, which really is more of a systemic model where you don't just have the two kids in conflict, but they are part of a larger class where perhaps the teacher doesn't have a lot of control, or there's a lot of peer pressure for this conflict to happen. And so in some schools, Sligo Middle School in Montgomery County, for example, and at Colbert, we started doing restorative circles where the entire class gets in a circle for a certain period of time. And the little dove, the peace dove you saw the kids passing around, that is a talking piece that is passed around, and there's a dialogue question that is addressed by the students. And we're finding that more systemic approach that really involves the whole community may be a better response than a mediation model that just has the two, maybe there's a way to do both together. So that's something we're constantly thinking about.
And so, for our clinic, I think the way we make sure that we're on top of what's most important in the community is by listening to the community itself and hearing what the problems are. And so, as I mentioned, what our students, and I mention Geraldine Detzer, who is my partner in crime on this, who's joined the clinic in this past year and has been a phenomenal addition as a staff attorney at the clinic doing this work. What we've been doing is, as I mentioned, going to drug treatment programs and doing some training right now on the Affordable Care Act. And we've also been talking with people in recovery, people in treatment programs about their questions. And we are invariably learning about where the real problems are with enforcement, right? And so so we are now taking their guidance and sort of learning where we have to go next. And so some of the benefits that we thought were the result of healthcare reform, we realized that on the ground, just don't apply in drug treatment programs because of other problems that exist. We just found out about this sort of the other day. We've been, telling everybody that, now that individuals have expanded access to Medicaid coverage, they can have retroactive benefits back for 3 months. Well, we've now learned, that doesn't work in drug treatment programs, because in drug treatment programs, many of the managed care organizations require that you get pre-authorization for your services. And so they don't want to give you pre-authorization 3 months in the past. And so a benefit that we thought was going to help our clients all of a sudden is something that points to another problem that, yes, can be addressed by other laws, but needs to be addressed. And so we are constantly, there's just no lack of problems out there to sort of keep us fresh and sort of trying to right the road.
So I really appreciate the question because, and I will even more appreciate any of your responses to it. It's a very difficult question to talk about community when you're speaking about criminal defendants. And it is that because most people most people here in this crowd, let's say, as good as you all are, you cannot imagine yourself in the Baltimore City Jail. You cannot imagine your children. Middle-income people, my whole life, middle-income people only become aware of criminal justice when something happens that's unexpected. And then they go, oh my God, is this the way the system works? What's wrong with our justice system? We have tried in so many ways, but I'm sure we haven't done nearly all that we should be doing. We certainly get a lot of thanks and appreciation from the families of our clients, and not all the time, but most of the time they are just thrilled that someone came forward. We made a video we've been showing all over the country about some of our clients and the thanks that we've gotten, but we have not done as well, frankly, in the legal community. Even though we have more support now, I must say that the support usually comes from individuals and not from organizations. So we have lots of individual public defenders who will come over and say, thank you so much for giving us a chance to be doing this work, or individual lawyers who feel very strongly that everyone ought to have a lawyer. But as a profession, despite our best efforts, life goes on. We have not gotten armies and soldiers volunteering to saying, this is outrageous. This is the most shameful act that one can think of when you're creating a justice system and you're willing to let people go without legal representation when their most precious human right is at stake, their freedom. I don't know, frankly, Renee, and I wish I had answers. I think the larger community is where we have not gone. We really need to go to the churches. We really need to go, to the, not just the faith-based community, but to organizations. We need to bring this issue to life, because right now, even though we've won the court victory, no one has gotten a lawyer when they first come to court in the last 6 months, even though we have a constitutional victory. Our Court of Appeals has already granted 3 stays. The legislature, as we talk, are trying to find ways not to do either anything or not very much. So this is where we're kind of stuck on this issue, and I would love my colleagues here, to maybe suggest things that we need to do, because community in this particular area has not coalesced around this issue.
Deborah.
First, I just want to thank you all. This was a really interesting panel, and it's energizing to hear about all of the diverse kinds of work you're doing and the focus that you have on the pedagogy. Thank you. But I have a question. And that is that I think some of the teaching that you must focus a lot on, you mentioned
Yeah, I tell them our first day of training that I'm going to have to unpack everything they've already learned for the first 2 years of law school, because they're overly focused on, well, what are the facts and what are the law, and that's the only thing that's relevant. So we use a lot of interactive exercises. We have a game called emotion charades. We do lots of simulations and role plays. You know, it is one of the reasons this particular clinic goes for an entire year is that training takes almost the entire first semester, because it is not intuitive, especially for law students who have been taught, you know, that there must be a right answer, and if I apply the facts in the law, there will be a right answer. And so, we do have a mandatory 1 full day training before we even have our first day of class. And we used to meet just once 2 hours every week, and I changed that in the fall semester to 2 classes, 2 hours every week, so that they can get the sort of the theory and the background, but then we have a lot of time for simulations and exercises where they're getting direct feedback from an observer. Does that answer what you were looking for, Bruce? Oh, gosh. I'll give you some. Let me think on that and see if I can come up with one to share with everyone. I mean, I think, you know, one thing we do just in the first day that I think is, I'll give you a couple of examples. So there is an exercise we do the first day called listening without, where the students pair up with another student and they have to think of some conflict going on in their lives, or they can take one from a TV drama or steal it from somebody else's life. And for about 3 minutes, there is a talker and there is a listener, and the listener cannot judge, cannot sympathize by saying, oh, I know the same thing happened to me, that reminds me of something, has to really listen in a new way. And that, I think, is very powerful. Another thing that I do in the spring semester after they're trained as mediators is I put them back in the role of an advocate, and we do a series of simulations where they are in attorney-client teams, opposing attorney-client teams, and they get a set of facts, and they have to do the legal research and write a pre-mediation statement, and I bring in actual experienced mediators to mediate the case. And so suddenly they have the knowledge of mediation, they're placed back in the role of attorney and client, and they just get such an appreciation for what it feels like to be a client and not be able to participate, or what it feels like as an attorney to do that strategizing about how are we going to negotiate, and do we start off with an apology to the other side, or do we hold that back as a negotiating chip? And so, so we just do lots and lots of simulations, and it's just great. It's a great way to teach. I don't think I could stand up and lecture for 50 minutes ever again, because it is just so interactive.
I'm going to take moderator's privilege just for a second to build on something that Deborah said, but go a little bit different way with it, which is, you know, students come in with preconceptions about what lawyering is. And all of you have talked about things that may not be congruent with their expectations about what lawyers do. So do you encounter student resistance to these different kinds of techniques that you're asking students to use? And how do you talk to them about having a broader conception of what it is that lawyers do?
So one of the biggest issues that we have in access to justice is when we get beyond the individual client. Everybody likes the individual client representation. Talk about changing a system and doing law reform, it becomes amorphous. It becomes too big for anyone to wrap themselves around, to think that he or she or they are going to be able to change something. And so I find myself having to find different ways to inspire, to persuade, to make people feel powerful as a lawyer, so that whenever they see injustice, they do not remain silent. That the silence makes you complicit with whatever the wrong is that you're seeing. So it's a whole sense of empowerment, but it's such a struggle. It's probably the biggest struggle I have every year, is to convince people that they can do it. So I bring in former students to convince them that they actually did complete something, or it's ongoing, and that they too can make a huge difference for an entire class of people.
I mean, and I think that it's interesting. I think students, at least students that I've encountered, obviously, are far more sophisticated, I think, in their understanding of what the law is now. And I think far different from when I was in law school, and people really did have a fairly traditional vision of an attorney being, again, in the public interest, sort of a legal services attorney, a civil rights attorney, and doing certain types of things. Now, students come to the law school wanting to know what policy advocacy is about and policy development, and they themselves have a vision of themselves as having a very different kind of legal career than we may have had. So in many ways, I don't think it is as much of a challenge to encourage and interest students in that, or to have them understand that that's a part of what a lawyer's role is. And then I think the other part is, to the extent that they don't quite understand certain roles. And again, when we had our students begin to do education in the community, many of them said that they really never thought about a lawyer as an educator. And again, providing them with some law review articles that spoke to that, right? And explaining how clinics do this all the time, it really began to have them understand how powerful that role is, not only to be able to assist individuals in their own self-advocacy, but how important it is for purposes of investigation. Again, a very kind of bedrock skill that all attorneys need.
I would just say that I think that this probably is an experience that all of us have, is that I don't need to convince them of that, because it's sort of organic. They get that through their work in the mediation clinic. And I think that, after they experience a mediation where they see parties just get totally transformed by the opportunity just to talk, that they get it. Or they see attorneys who are sort of destructive to their clients' goals, and then they see attorneys who are very good at recognizing interests and reflecting interests and really helping the process. And so I don't know that I try to convince them of that, because I think it is something that if they don't get it through the actual work, my saying it's not going to be as powerful as what they realize as they go through the clinic, and they do. So some come in thinking, oh, well, you must be an evaluative mediator. You have to tell them what the law is. You have to tell them who's right and who's wrong. And that changes throughout the year.
So that's interesting for those of us who teach. In some ways, teaching client-centered lawyering is harder than convincing them that all of this other stuff is important, right? Getting over that sense of who a lawyer is supposed to be and that authoritativeness that they think a lawyer is supposed to have. Other questions? Sarah?
So, first I just want to say, I know what each of you teach, but it's such a privilege and so nice to have this kind of time-out day to hear about what each of you do, because you just think about it in such a way and realize what a great place this is. I guess my question relates to, as you are developing your clinics and responding to evolving community need and advancing social justice, there's also, as you all talked about, the piece of teaching skills, practical skills and experiences to students. And for those of you, and I'm thinking of Ellen in particular, but maybe it applies to Deb and Doug also, for those of you who don't have a steady intake stream of cases, and you anticipate what the community needs are going to be and anticipate what the experiences are going to be for students to teach the skills that you hope to teach as you embark on your semester, your year, and because it's real world, it doesn't actually play out that way. How do you ensure that your students have equal experiences and get the skills that you hope to impart at the beginning of the semester?
That is,
I'm looking at Ellen.
can I pass on that?
Hey, Ellen, if you want to think, I have one answer.
Great, okay. What a great pass.
So, since I started teaching, I've taught through a semester-long simulation. And that semester-long simulation, because of what I do, right, starts with an initial client interview and moves through each of the skills that I think it's essential for my students to have. So because my cases are often at different places, not every one of my students is going to get a case that starts at the beginning and goes to the end. But every single one of them is going to move through that simulation. Everybody's going to do an interview. Everybody's going to do case planning. Everybody's going to do counseling. Everybody's going to do trial skills. And so to the extent that it's possible, I think that for me is the best use of the seminar component, which is to ensure that they get that equality of experience there. Did that give you time?
Still I'll have an inadequate response, but I think one of the things that was such a challenge this year, interestingly, is that we decided to take on implementation of the ACA. And in part because, one, we had to get such a grounding in the law, and the students had to get such a grounding in the law, it really upended any of the kind of planning that we had hoped. Plus, our vision of how the law would be implemented in the state was, again, far different than what happened given the problems with the rollout, right? And so some of the types of things that we anticipated would be happening, one, didn't happen at all, such as the ability to do, client interviewing, client counseling. I mean, that has come much later in the year. So my clinic is a full-year clinic as well. That's now happening now. I mean, all of the skills that one would need, client interviewing, fact gathering, all of that work and skill stuff we taught in the first semester. We did it in connection with simulations around the ACA because we didn't have any live cases to work on. And so we built it in that fashion. And so you can anticipate that and build that in, and so that's what we did. But some of the kinds of things like, case theory, right? You could come up with a simulation around that, but you don't have a real case to, help somebody struggle through case theory. So that was a challenge. That really was a challenge. I think we're looking forward next year to having some, a much more steady foundation. The law is in place. We are already gathering, examples of problems, and we can really have some real live stuff, and so we can really have a much more systematic way of presenting that, grounded in real cases, which will certainly help them.
So we actually do an involved simulation for the first 3.5 weeks. The students they have cases, and my clinic twos and I, we play many different roles so that they get the experience of interviewing, case theory, investigation, fact gathering, negotiation, advocacy. At different times, if you ever pass by my office, I'll either be not Investigator Clouseau, but I'll be Investigator Doug, or I'll be Supervisor Doug, or I'll be Professor Doug, or I'll be, and it's all these different roles that allow students to actually do these things. We tape them, we go over them on the videotape, because all of these skills become very important for the individual client, which then allows them to buy in more to the law reform piece of it.
So there's another question, and then I'll come back to you, Deborah. Yes.
And it strikes me that your clinic has a very potent medical legal aspect to it. And I was just wondering if you represent clients who are institutionalized because of medical reasons, or representation to either the released or those who are released to, community needs some more representation that they should be institutionalized.
We have not undertaken that. And so, again, certainly a number of persons with drug and alcohol problems are institutionalized, but they're institutionalized in jails, unfortunately. And I understand exactly what you're saying. I fully appreciate that. Quite frankly, I mean, in our state at least, I mean, you find far more individuals with mental health problems who are institutionalized and who need that representation, and we've not undertaken that. We've not undertaken that. So, most of the individuals, again, that that we represent, at least what we've done in the past, have been individuals who have faced discrimination problems as a result of their history of a drug or alcohol problem. In the past, we'd also done some work in the child welfare system on behalf of women who were losing their children because they had a drug or alcohol problem, whether in current or in the past. And so we had done advocacy and representation in that regard. And I think the work that we're going to be doing under the Affordable Care Act is what we've at least initially envisioned, apart from our parity work, in which we represent individual programs and individuals themselves who think there's a violation of the Parity Act. We will probably be working more on behalf of individuals who have incorrect eligibility determinations. And so that's where our work is really focused, in order to ensure that access to the care.
Deborah, did you?
It's easier to not panic about subject matter and think with the students about, and make sure they know that's what you learn. Take it and keep applying it to new contexts.
Other questions? So one of the things that you all talked about, or most of you talked about, was doing legislative work. And I think legislative work with students has particular challenges. So how do you figure out what kind of legislative work you want to do, and how do you make that a meaningful experience for students?
So I've done legislative work in the mediation clinic, believe it or not, and when I taught the workers' rights clinic. And so the students are really excited to do legislative work. So in the mediation clinic, the students played a very important role in the mediation, the Maryland Mediation Confidentiality Act. And they were really excited to try to educate legislators about mediation confidentiality and why it matters and what the exception should be. And in the workers' rights clinic, the students really like finding real people with real life stories and helping to prepare them to come testify before the General Assembly is something that they just loved. Our students here love doing policy work. So I don't know if anybody else has found resistance to that, but in my experience, the students really are eager to do that type of work.
And, and that's been my experience as well. And perhaps it's because the students come to this clinic because it's called a drug policy clinic, so they have some sense that there's policy involved in all of this. But I mean, partly, I think, as in any situation, to the extent that there's sort of a compelling issue that really draws the students in, they just take it and run with it. So one of the things we worked on last year was a bill to ensure greater access to naloxone, which is the antidote to opiate overdoses. And we were actually asked by the Department of Health and Mental Hygiene to draft the bill that would make access for third parties, meaning individuals who weren't themselves the opiate user, but a friend, a family member who would be in the most effective position to reverse a person's overdose. We were asked by DHMH to draft the bill because there was a legislator who wanted this bill drafted, a constituent that became really the leader of our coalition had asked this bill to be introduced. The sponsor wanted it introduced. She didn't have the capacity to draft it. They turned to us. And so the students had this wonderful experience because in the first semester they had been evaluating that issue, had decided what the legal standard should be, they had identified a model for the bill, and then it was dropped in our lap as with a request to draft the bill. So they drafted the bill. They drafted all of the advocacy materials that went along with it. They worked with our coalition of physicians and mothers and treatment programs to organize the testimony. They themselves presented testimony, and they obviously did all the advocacy with the key members of the committees. And so that was like I think a dream situation. It doesn't always follow in that path. I mean, we have worked on many other pieces of legislation, I think, equally effectively, and have obviously not gotten that kind of situation coming together. But nonetheless, the same kind of pattern has followed in all of the work that we've done. We've drafted parity bills. The students have developed those bills. They have drafted the testimony, and they've presented it, and they've done the advocacy. And again, I think it's all of those incredibly important skills all wrapped up in that effort.
So I'll just make it brief that I agree that students overall have enjoyed the legislative process. They've testified. I think they've done a wonderful job. They've done some lobbying. This year I encountered for the first time resistance from the organizations that have an interest in particular issues. And I actually was not told but asked if students could refrain from getting too involved because there was a fear that they might say the wrong thing. And I reassured in so many ways that students are so capable, and you folks don't have the troops, you might think you're doing a terrific job because you're the professionals, but actually most of the legislators want to hear from real people who had real clients. And so I think it's an issue that we're going to encounter more, not less, as in terms of whether we're going to be invited in, and I just chose this year not to intrude there. It was a little bit too delicate, and I decided we can stand off this year. There's other ways we can try and influence.
Well, and that's not an unusual experience for us this year. At least two of us have also had that experience this year. And so I think it points to one of those challenges, which is, when you are in the community as an advocate and people look to you as an expert, how do you make sure that your students can be front and center in a way that others are willing to accept? And I think that that's something that we'll be talking about and thinking about kind of as we go forward. So we only have a couple of minutes, and I'm going to give you a hard one. So unless anybody else has a question? So what's the single most important thing that you want your students to take from your clinic about lawyering?
For me, it goes back to what Deborah said about making strategic choices. That's something we really emphasize in our clinic, either strategic choices as a mediator, right? Do you make choices to caucus or not caucus, to ask a question or not ask a question, and strategic choices as a lawyer about when a client comes to you with a problem or a goal that the client wants to achieve, what's the best process for achieving that goal? What's your negotiation style? What's your negotiation strategy? Is it negotiation? Is it mediation? Is it litigation? Is it policy advocacy? Sort of understanding the whole realm of tools that lawyers have to accomplish a change or to solve a problem for a client, and then using them effectively. So that's the most important thing. Just something real tiny.
Just that little thing.
So I think it's professional responsibility to improve, enhance the administration of justice. I'm not as concerned that students do get the individual client. We can't teach the individual skills. I want them to believe that they can make a difference in addressing systemic problems and not just leaving it for the next one to do it or accepting it as is.
In addition to all of the things that both Deb and Doug have mentioned, I think the other important thing is for students to identify what their passion is in the law and to really, seek that out and to figure out how they want to live their lives and what they want to fight for, and to go for that.
Well, that's a great way to end. I want to thank our panel for getting us off to a great start this morning.